One of our favorite secret weapons for problem solving and negotiating is local real estate attorney Brian Lytle. In this series of Get Smart, Brian shares his insights on the purchase contract.
Hi, I'm attorney Brian Lytle, and this Get Smart segment is on understanding the contract. And this segment is big picture. That is, it's not specific legal advice. You certainly don't want to make a determination whether you can not perform under the contract. Those are always fact-dependent and contract-dependent. So this is just really a broad overview in order to help you understand how the contract works. And Liz Moore, as a company, has offices in really three different areas that use three different contract forms, and they stem from the different realtor associations. For example, one is the RAIN. You see where I'm flagging it on the screen. RAIN is an acronym for the Real Estate Identification Network. CVR is the Central Virginia Realtors Association. That's in the metropolitan Richmond area. And then VR is the statewide Virginia Realtors Association. Each of these develop and promulgate form contracts for their member agents to use. Each of those contracts handles things a little bit differently, and in some cases much differently. But as a general proposition, there's quite common threads in how things are done, and the reason for that is all the contracts really are fairly drafted for both buyers and sellers. That is, buyers have certain reasonable expectations about the purchase, and sellers have certain reasonable expectations regarding the sale of the property. And so the contracts do a really good job of melding all of that together so that your Liz Moore agent can use the same form contract whether he or she is representing the buyer or the seller. So that's the purpose of this Get Smart segment. In other segments, we will drill down on specific provisions and topics, financing, for example, and home inspections, that sort of thing. If you have any questions about this segment or any particular provision of your contract, then ask your Liz Moore agent, who's among, if not the best trained agents in the state. And of course, we have terrific resources both at the broker level, and then I'm there to help everybody out as well. So from a big picture standpoint, just like the journalist credo, we can break it down into who, what, price, when, how, condition, contingencies, and disclosures. And so let's take a look at those. The who, obviously, is who are the parties. On the screen is a sample preamble for the Virginia Realtors form contract, but they're all pretty much the same. We're going to identify who the buyers are and who the sellers are, and this is important, and you should pay attention and make sure that it's done accurately. The what, of course, is the property. Here's another sample paragraph from one of the contracts. They're all somewhat similar. Here the agents and you are going to provide a legal description for the property. That's typically the mailing address, sometimes a short legal, say for example, Lot 3, Kings Mill, James City County, that kind of thing. That's what we call a short legal description. And the agents will typically put in a tax identification number, GPEN number. Each of the municipalities in Virginia, the cities and counties, have a number that corresponds that they give the property, and the agents will usually list those. So you want to verify that. If there's multiple lots or acreage or something of that nature, make sure the legal description is accurate. Note here that among the what, of course, is personal property. Each of the contracts handles personal property a little bit differently, Just know that that's something you should review carefully, make sure you understand it, and that personal property that you expect to transfer is listed, and there's no personal property that you don't expect to transfer that is listed. The next in the big picture would be how much, the price. Again, all of the contracts lay this out a little bit differently, but they all fundamentally work in the same way. You're going to start by showing the total purchase price of the property. You're going to indicate whether there's, and then how that purchase price is going to be paid. How much of it is derived from a loan, if the buyer needs a loan. If there's a deposit going to be made, is that being applied to the purchase price? And then lastly would be the funds that are necessary to closing. So you have a gross purchase price, loan amount, deposit, due at closing. Of course, there are closing costs for a buyer that are on top of that. But this is really just spelling out how much it's being purchased and sold for and how that money is derived. Next, of course, there's a little bit more how, because we're specifying, all of the contracts will specify if there's financing, the conditions on that financing. There are going to be time period. It's going to obligate a buyer to move forward really in good faith and with due diligence on getting that loan. Again, the contracts are all a little bit different, but they're all similar in those respects. And buyer's got to pay for the credit report, make the application, move it forward, do what's necessary to get an appraisal, cooperate with the lender. There are going to be provisions that permit the lender to share information about loan status with the listing agent, so that the listing agent and the seller can track and make sure that the buyer is doing what he or she is supposed to be doing. If there's a loan denial, obligations about reporting that. So it makes sense that if the buyer's ability to purchase the property, the house, is contingent on financing, those terms are going to be spelled out. The contracts are also going to note whether it's a VA or FHA loan, conventional loan, or cash. A little bit more how. If you think about it from a buyer's standpoint, the buyer wants to make sure that the buyer's getting clear and marketable title, free from encumbrances and liens that don't affect the ability to use the property for residential purposes. So again, all the contracts are just a little bit different, but they all provide adequate protection to a buyer to make sure that the buyer's getting proper title to the property and that it's insurable. A couple of other things, a little bit more how to note. There's always a risk of loss provision, and that simply says that up until title transfers, that is the closing, the seller bears the risk of loss. If the house burns down, the seller's responsible there. Of course, the seller should have insurance, but risk of loss is not just catastrophic, it's also small. So if the buyer signs the contract and all the windows are in good shape, and then prior to closing, 2 of the windows get broken, well, the seller's responsible for delivering the property in substantially the same condition, and that comes within the risk of loss provision. All 3 of the contracts have a similar provision. There's nothing weird or unusual about that. They all, in some form or fashion, have a mediation clause, and that simply provides that before the buyer or the seller sue one another for breach of contract, the parties are obligated to mediate their dispute first. Mediation's not arbitration. Arbitration's where somebody decides. Mediation is where a third-party neutral gets the parties together to see if a compromise can be reached. Next, in the big picture, understanding the contract, a couple typical provisions are settlement date and prorations. On the screen, you'll see 2 sample paragraphs. Again, each of the contracts is a little bit different, but
This is a reminder.
they're all going to specify a closing date. Whether that closing date is hard or fast depends on which contract you're looking at. As a general rule, the parties need to close on that date. and they need to act in good faith and with due diligence in doing that. There may be the ability to extend it for a brief period of time, depending on the nature and the reason for the extension, but don't presume that the closing can just be extended. All the contracts have a expenses and prorations clause. The paragraph 10 on the screen is an example of that, and they all basically say the same thing. Each party bears their own closing costs, and sellers really don't have much in the way of closing costs. Of course, there's the listing agent's commission. There's something called grantor's tax. Seller's responsible for the fees in getting the deed prepared. There may be like a termite inspection the seller's paying, but generally sellers, don't have that many identifiable closing costs. Most of the closing costs are buyer costs, and that's because recording taxes, everything in connection with the loan, the buyer's responsible to pay for all of that, unless there's a provision in the contract differently. Some of the contracts, and you see this is an example from the VR contract, the purchaser has to purchase any remaining fuel, oil, or propane in tanks. The other contracts don't have that provision, so just make sure you understand that and plan for it. You don't really need all the contracts have a provision about rollback taxes. That's an unusual circumstance where maybe the zoning got changed, upzoned from agricultural to residential, and the municipality is letting the seller not have to pay the higher taxes until the property's sold. That's pretty rare, but typically that should be a seller expense. The next big area of clauses takes up 3 or 4 pages typically, are talking about the contingencies, and a contingency is what has to occur prior to a party being obligated to perform. So for example, the first one I have listed here is financing. Well, so the buyer, if financing is noted, buyer needs to get a loan in order to buy the house, which is pretty typical. Then the buyer's obligation, duty to purchase the house is contingent upon the buyer getting that financing. So that's a contingency. In order to get the financing, if you have particularly on a VA or FHA loan where it's mandatory, but also typically on a conventional, the property needs to appraise high enough so that the buyer can borrow the appropriate loan-to-value ratio against that appraised value. So you'll see a number of different provisions there. If you've got a conventional or there's a cash deal, then an appraisal may or may not apply. It's always a deal point, a negotiation point between the buyer and the seller. If the buyer needs to sell a house that the buyer presently owns in order to be able to purchase this new one, then that needs to be specifically set forth in the contract as a contingency, and the seller has to agree to it. The buyer can't hide that. They're making specific representations that that's not the case. Likewise, some of the contracts obligate the seller to disclose whether he or she is in bankruptcy or it's a short sale transaction, because under those circumstances, third-party consent is required. So talk to your Lismore agent if you have any questions about those two contingencies. Likewise, because of Virginia law, if the property's in a property owners association or it's a condo in a condo association, then by law there's a required disclosure, and it's automatically a contingency. That is, the buyer's going to be able to review the association materials or condo materials, and will have a 3-day right of rescission. Again, you should review the specific provisions so that you understand them if you're in that circumstance, and follow up with your Lismore agent as well. Of course, there may or may not be a contingency in terms of the property condition. So acceptable inspections are also are contingencies under the contract. And to talk about those a little bit more, the condition of the property, So understand that in Virginia, Virginia is basically a caveat emptor state. That means buyer beware. You kick the tires, you test drive, you do whatever you're going to do, but that's on the buyer to figure out. There are some exceptions to that general rule. First, of course, the buyer can make the deal contingent upon a home inspection, and there'll be a clause and an addendum for that. If it's on a well or septic, each of the contracts provides that needs to be inspected and okay. There are also provisions for termite and moisture inspections to make the deal contingent on those. Particularly in the Richmond area, the CVR contract, radon can be a little bit of a concern. So in that area, typically, or the buyers may want a radon inspection. There may be repairs that are specified in the contract from the beginning. So that'll be a condition of the property clause that might well be a contingency as well. Similarly, all the contracts in some form or fashion have a walkthrough provision where you do that a day, preferably a couple days, or the day before closing, not the morning of. And the purpose there is to verify the condition of the property. It can get a bit tricky in terms of what you can ask to be repaired or what a buyer can ask to be repaired as a result of a walkthrough. That usually depends on whether or not there was a home inspection. So we can't really make any blanket statements about the walkthrough, but you'll see those clauses and should make sure you understand them. Sellers don't want to be caught. Again, when we look at the idea of kind of what's fair, reasonable expectations that I mentioned at the beginning, well, if a seller, selling a $300,000 house and come to find out, unbeknownst to the seller, there's $50,000 worth of repairs, well, the seller probably wouldn't have sold the property, and the seller may not be able to sell the property. So all the contracts have a provision to cap the seller's unknown repairs. Of course, home inspection negotiated repairs are always outside of those caps. So the idea is seller's protected against things to the extent of the cap, that's specified in the contract, but the seller's protected to that extent. But then if the seller knowingly negotiates the cost of repairs, they're going to be outside of any cap. Another large part of the contract, again, this is probably 3 pages worth on each of them, are just general disclosures, reminding you again that it's caveat emptor. So these are only the limited set of statutory disclosures. Virginia has what's known as a Residential Property Disclosure Act, and in my view, that's pretty much of a misnomer, because what that act says and confirms to the buyer is the seller really doesn't have to disclose anything. If you're moving here from California or a state that has condition disclosure obligations, Virginia doesn't. So when you get that Residential Property Disclosure Act form, buyer, you need to read through that, because basically what it's going to say is seller doesn't have to disclose hardly anything. As we noted earlier, the seller does have to disclose whether the property's in a POA or a condo. Virginia law requires disclosures about mechanics liens. That's where a bill remains unpaid and a contractor, for example, can file a lien. That's one reason the settlement agent is going to require that those bills be paid at closing, or proof that they've been paid. Virginia has language that obligates or advises the buyer and the seller that the buyer has the right to choose the buyer's settlement agent. Of course, the seller has the right to choose the seller's settlement agent as well. Federal law, if the property's built prior to 1978, federal law requires a lead-based paint warning. All the contracts have a version of what we call Megan's Law. That is, if a buyer wants to know whether a sex offender lives next door, that's up to the buyer to figure out. The seller's not making any representation about that, nor are the agents. Within the Residential Property Disclosure Act, I mentioned there are some specific required disclosures. If there's defective drywall, that's the old Chinese drywall that came up a number of years ago. If the seller has actual knowledge of that, or that the property's been used as a meth lab, or it's in a military air installation noise zone, potentially in a tourism zone. If the seller has actual knowledge of any code or zoning enforcement actions, those have to be disclosed. So those are the limited required disclosures, and you'll look through and see that in all of the contracts because they have to be there. So that's really the big picture of the contract. You're identifying the parties and the property and how it's being paid for and how much it's being paid for, the general mechanism about how the transaction is go forward. The parties, you're negotiating the condition of the property and what inspections are going to be performed, what caps and who pays for what. The statutory disclosures are there, and then there's ancillary items like we talked about, the closing cost and the title and all of that. So when you look at it that way, it's not that complicated, but of course, the devil can be in the details, particularly if there's a dispute between the parties. It's really very rare to have that. Most transactions go very smoothly because the contracts are well written and the parties know what they're obligated to do, and your Lismore agent works with the other agent to get that done. Just to summarize, when you eventually sign that contract, go through it, make sure all the blanks are filled in, that they're filled in accurately. Understand that there's no side deals here. You can't say, well, the email said this or the email said that. Everything needs to be in the contract. You're not going to be able to reference any oral understandings or ancillary documents. Also ask yourself if there are any other contingencies that haven't been listed. From a buyer's standpoint, is there a particular use of the property or planned improvements? There can be restrictive covenants and things like that prevent you from having the chickens you want to have for your kids or the metal detached garage that you want to build. So think those through and talk to your Lismore agent to determine whether they should be, and those items really should be contingencies in the contract. And ask yourself if there's anything else that needs to happen in order to consummate the deal. That's the end of our Understanding the Contract segment. I appreciate your patience. Again, you contact your Lismore agent if you have any questions, and if there's a specific topic, look for another Get Smart segment on that topic. Thanks, and have a great day.
Be sure to subscribe and turn on notifications for our next installment of Get Smart with Brian Lytle.